you, my Lord. Could I ask you to turn to electronic page 2739, which is the start of the Target Ventures judgment. 2739. Thank you. I do need to locate this a little bit more than I otherwise would in the facts of the case for a reason which will become apparent. So if I could ask you to turn to 2740. The intervener, paragraph 1, Target Partners GmbH, established in Munich, Germany as a venture capital fund. It has been the proprietor since 2002 of, in particular, the domain name targetventures.com. So please note that date, 2002. And since 2009 of the domain name targetventures.de. However, the content of the websites registered under those domain names has only ever referred to Target Partners, which is the sign under which the intervener offers its services. Those sites are merely a means of redirection to the intervener's official site, targetpartners.de. Indeed, they display the content of that site. So just pausing to get the picture because it's confusing over who's the intervener and who's the applicant. The proprietor has got a trademark, having had domain names incorporating the feature Target Ventures and Target Ventures, which they used as a redirect to their main substantive commercial website. The applicant, so that's the objector in this case, the applicant, Target Ventures Group, established in BVI, also claims to be a venture capital fund. It claims that it has been operating under the sign Target Ventures on the Russian venture capital market since 2012 and on the EU market since at least 8th March 2013. Pausing there, you'll notice that this is after the prior use which has been referred to in the preceding paragraph. It submits that between the 23rd of December 2013 and 18th December 2014, it provided financial and monetary services under that sign to 5 undertakings established in the European Union. It argues that in return for its financial contribution, it acquired holdings in those undertakings on behalf of its own investors. It submits that those investments are attested to by a number of specialist websites and so on. On the 13th and 14th of November 2014, 2 partners of the applicant, so that's the objector, or of a third party operating under the name Target Ventures, as well as a representative of the intervener, attended a well-known conference in the investment sector in London. On the 13th of November, a representative of a start-up undertaking looking for investors sent 2 emails to those 3 people, jointly addressing them by their full names. Their email addresses ended respectively in targetpartners.de and targetventures.ru and were visible in those emails. Then you get the application of the date for registration. On 27th of January 2015, the intervener filed an application to register an EU trademark with the EU IPO pursuant to the regulation. Registration as a mark was sought for the word Target Ventures of the contested mark. That is the contested mark, Target Ventures. The services in respect of which registration was sought are in classes 35 and 36, and they're specified. They're certainly not as long as some of those you see in these cases. The trademark application, paragraph 6, was published on the 18th of February 2015. 18th of February, having received an email dated the 7th of July, sent by a client who had supposedly confused it with the applicant, that's the objector, which was organising a promotion event in Berlin. The intervener, that's the proprietor, sent the applicant a cease and desist letter followed by an application for an interim injunction at the Landgericht Berlin, which it withdrew after reservations were expressed by the President of the Court. And you'll see 13th of July 2015, the applicant filed an application for a declaration of invalidity on bad faith grounds in respect of all the services referred to in paragraph 5 above. The Cancellation Division rejected the application for a declaration of invalidity in its entirety. The applicant appealed. By a decision of the 4th of February, the Second Board of Appeal dismissed the appeal on the ground that the applicant, that's the objector, had not proved that the intervener, that's the proprietor, was acting in bad faith when it filed the application for registration. Now, the reasoning of the Board of Appeal comes to be criticised, and I can, I think, pick up what the criticisms are and what the reasoning was when I take you to the substantive portions of this judgment. So, may I turn you then to 2743. You see in paragraph 25 the familiar language that's being cited there, while in accordance with its usual meaning in everyday language, the concept of bad faith presupposes the presence of a dishonest state of mind or intention. That's all from established CJEU case law, and they attribute that to Cotton at the top of page 2744, which is correct, of course. 26 is again a recitation, I think verbatim, of Cotton. 27, in the first place, in starting in paragraph 19 of the contested decision that bad faith involves conduct which departs from accepted principles of ethical behaviour or honest commercial and business practices, and presuppose, and you'll see Advocate General Shaftesbury's words, a dishonest intention or other sinister motive, the Board of Appeal interpreted the concept of bad faith too restrictively. It is apparent from the case law cited above that the intention of obtaining, without even targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark, in particular the essential function of indicating origin, may be sufficient for it to be held that the trademark applicant was acting in bad faith. And then they say it isn't necessary for the purposes of categorisation that the applicant had knowledge of a third party's use or would be targeting that third party, that's 28, and that the Board of Appeal erred, it says in 29, for indicating that such actual or presumed knowledge was necessary. It then refers to the Court of Justice in Cotton, it then refers to Lint and Cotton again in paragraph 30, and it is indicating that prior use is not required. That's how it ends. Consequently, knowledge on the part of the proprietor of the contested mark of a third party's prior use of that sign, or the question of whether that proprietor ought to have had knowledge of such prior use, is only one relevant factor among many to be taken into consideration. They make the point that the various factors are not exhaustive. You can find that through 31 and so on. Now, if I get to the meat of it, paragraph 35 on 2745, as regards in particular the question of whether the intervener sought registration of the contested mark without having any intention of using it for purposes falling within the functions of a trademark, in particular the essential function of indicating origin, it's apparent from Sky that although the applicant for a trademark is not required to indicate or even to know precisely on the date on which his or her application for registration is filed, or of the examination of that application, the use he or she will make of it, and although there is a period of 5 years for beginning actual use consistent with the essential functions of the trademark, the registration of a trademark by an applicant without any intention of using it in connection with the goods or services covered by that registration may constitute bad faith, where there is no rationale for the application for registration in the light of the aims referred to in the regulation. Such bad faith may, however, be established only if there are objective, relevant and consistent indicia tending to show that when the application for registration of the trademark was filed, the trademark applicant had, and there's the familiar words, the intention on the one hand or the intention on the other. Then they look at this case. In the present case, it's apparent from objective, relevant and consistent indicia that the intervener's intention at the time when the application for registration of the contested mark was filed was not to put it to a use falling within the functions of a trademark. First, it is stated in paragraph 37 of the contested decision that it cannot be excluded that the intervener wanted to protect its clients from possible confusion between the sign's target partners and target ventures, and that the commercial logic behind the filing of the contested mark was the intervener's legitimate desire to protect its distinctive name, Target, accompanied by the description of its venture capital services ventures, in addition to its mark target partners, and thus prevent any confusion among its clients. However, in the specific circumstances of the present case, the fact that the intervener registered a mark in order to prevent a likelihood of confusion with another mark of which it was already the proprietor, and or in order to protect in that connection the element that is common to those marks, is, as the objector in essence submits, extraneous to the functions of a trademark, in particular the essential function of indicating origin, and contributed more towards strengthening and protecting the intervener's first mark, which was both before and after the application for registration of the contested mark was filed, the only sign under which the intervener offered its services. Second, it is clear from the intervener's answers to the questions put to it at the hearing that the intention which gave rise to the filing of the application for registration of the contested mark was that of strengthening another mark, namely target partners, since the websites did nothing other than provide a means of redirection to the intervener's main website. Indeed, the intervener stated the contested mark had been used as it had been before it was registered in connection with the website in order to redirect interested consumers to its main website on which it offers its services. It also stated that that was the main reason for its use, according to the intervener, by using a distinctive element, namely the element target, with an element that's descriptive, namely ventures, and by providing a means of redirection to its main website on which it offers services under the mark target partners, it intended to show the interested public that those services were also offered by target partners. It submitted that the reason for the registration of the contested mark was therefore that of protecting the signed target used in the name of those two websites. The intervener also declared that it wished to broaden its portfolio of trademarks. Given first that it's not disputed that the use of the sign has been the same before and after the filing of the application for registration, namely that of providing a means of redirection to the intervener's main website, DE, and given second that it may be deduced from the intervener's explanation at the hearing that the protection of that use was the principal reason for the application for registration of the contested mark, no information of any other planned specific use having been provided, it must be held that the intervener solely had the intention of continuing to use that trademark in the same way as it had been doing before that application was filed. Consequently, the intervener filed that application not with the aim of engaging fairly in competition, but with the intention of obtaining, potentially without targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark, in particular origin. Third, as regards the general claim that it cannot be ruled out that the intervener filed the contested mark because it wanted to expand the use of the sign target ventures, it must be pointed out that that claim is contradicted not only by the lack of any use of that sign other than that which had already taken place before the application for registration was filed, but also by the intervener's statement at the hearing regarding the main reason for the use of that sign and its intention at the time, and by the fact that the intervener has ensured that it's identified in the minds of clients exclusively with the marked target partners. 43 is really quite startling. It's clear from the intervener's reply to the email of 7th of July 2015 that it wished to state clearly to the client in question that it was not it that was organising the promotional event, without, however, mentioning that it was using the name Target Ventures. It's also not disputed that the intervener has never offered its services by using the sign Target Ventures in order to do so. On the contrary, the origin of the services offered by the intervener has always been identified by the marked target partners. Then you see this. Consequently, the intervener, even subsequent to the filing of the application for registration, used that name to the exclusion of any other for the purposes of identifying itself to its clients. Now this is, it's absolutely astonishing. So at a purely factual level, there have been umpteen cases in which people have used as a domain name with a redirect to a commercial website, used a domain name which is identical or similar to a registered trademark, and that has been found to be, without hesitation, infringing use. It's one of infringing use, that is, use of the trademark in the course of trade for goods of the kind for which the goods are registered. You infringe, and there have been any number of cases involving the online retail traders. I'm just going to mention at large without being specific. There's Amazon, of course, and there's the Google search references, all those Google cases and so on. This, that is to say, the use of a sign in a domain name which redirects you to a web page on which you land, in which they are offering goods and services of the kind covered by the registration, is classic trademark use. It is astonishing that the court should have taken this view at a factual level. There is ample case law, and my Lord Kitchen in particular will be aware of it, having made the reference to the CJEU in Specsavers. There's ample case law in Specsavers and the Colosseum case which preceded it to say that you can use a mark in conjunction with or in association with another mark, and it still counts as use of the mark that you are using, the first named mark. There's a whole line of case law which says it's perfectly possible to have a family of marks, and you can start a new family, as it were, by introducing the new use of it in this way. Now, this case, this judgment, was not intending to, you can see enough, not intending to and couldn't anyway depart from the CJEU case law in Sky, Cotton or Lint. It just simply couldn't do that. There was a total failure to consider the 5-year grace period to see whether the proprietor would ever go on to use the mark in accordance with any of its protected functions. There's no discussion of the wide notion of the protected functions doctrines which you get from the case of Mitsubishi. And the analysis, with the greatest of respect, is very, very difficult. It's impenetrable to follow about the domain name or the redirect not involving use in relation to the commercial content of the landing page. It is, in fact, impossible to understand that reasoning. Now, what then is the correct interpretation of this case? Because it's not my function to say it's wrongly decided. It's a case decided on its own facts. This case seems to stand for the proposition, as far as I can make it intelligible to your lordships, this case seems to stand for the proposition that a domain name is not itself a trademark, and using it as a redirect to some website which is a full commercial website doesn't involve use of it as a trademark for a trademark purpose. That must boil down to the proposition, which I can only paraphrase as saying that the mark in question, the mark that went on the register, having been the domain name, was simply a mere cipher. It was a I don't know what it was. It had no functional status according to this court. So the ruling of the court is that if a mark has no functional status, if the sign that's been put on the register has no functional status, then in those circumstances it can't be regarded as a mark for the purposes of identifying the goods to which it refers. Therefore, this was a judgment which stands not as a non-use case, but as a non-mark case. Now, whatever else you can get out of this judgment with the greatest of respect, even combining it, as the Lord Justice Arnold did in Lidl and Tesco, with my Lord Kitchen's judgment as the appointed person in Kinder Snappy, neither separately nor together do these cases stand for the expansive proposition whereby the judge ended up saying that bad faith applies to cases which are not involving simply dishonesty, but can involve overbroad filing of applications for registration. This was over-interpreting this case law. I mean, really seriously over-interpreting this case law, in my respectful submission. So I just wanted you to see, because my learned friend drew upon it, referred to it, said to your lordships, please take the time to look at it. I just wanted you to see, while I was here to deal with it, that those two cases together don't support the general proposition that the judge was intent upon establishing, and that general proposition is part of a judgment which attempts to reorientate the judgment of the Court of Appeal in our Sky and SkyKick case. My Lord, time presses. My Lord Law Readers indicated that we have full written submissions. I'm going to reach a point very shortly where Mr. Roberts is going to be saying he's got the infringement side of this case. He'll be making some submissions to you. The one thing I must go to is the Brexit point, not least because it involves the question of what the law is that we're considering and applying. I said to you that there's a correction I must make, and I must make it straight away in case I run out of time in a few minutes from now. So if you look at electronic page 173, in paragraph 27 of our written case, it's 27 where I say, and I actually thought it was the case at the time I wrote this, well obviously I thought that, the relevant EU legislative provisions have in substance been carried forward into the EU TMR 2017 and recast TMD 2015 where they subsist, present tense, as retained EU law within the scope of that expression as defined in section 6.7 of the European Union Withdrawal Act, but have since the end of the transition period been subject to the governing provisions of the withdrawal agreement. Now that's wrong. I discovered, well, much to my surprise really, but I discovered it nonetheless, that tucked away in the statutory instrument, and that's the second document that may have reached you from the Supreme Court Registry.
Yes.
It carries Schedule 5 at the top of it, if it's reached you. If not, I've got hard copies.
Yes, it's a 2019.
Yes. Now, where that belongs in the scheme of things is it's a continuation of what's at core, tab 106, and I know your lordships are going to say that the tab doesn't help, so I'm just going to find the page, or perhaps Mr. Roberts can find it. 1894. 1894. So this is a continuation of the secondary legislation that you have at 1894. Was that it? Yeah. Can you pass copies? Thank you. Now, the provisions, which I have to say took me by surprise, Schedule 5, look to the right, is introduced by Regulation 6 in the body of those regulations. So that's on the front piece of what I've just given to you. And then you look into numbered page 2 of what I've sent you. Is item 6, Regulation 6 is repeals and revocations. That's paragraph 6. The enactments listed in column 1 of the table are repealed or revoked to the extent specified in column 2, and then you run your eye down, and the whole of the 2017 EU trademark regulation has been repealed in its entirety in the United Kingdom. Now, this is, as you may be appreciating, this is creating a mess. At the same time, your lordships would need to look across. So it's numbered page 3 in the material I've sent you. You see transitional and saving provisions, paragraph 7, and then you run an eye down, and there's a sub 2, 7.2. The repeal of section 52 of the 1994 Act. Power to make provision in connection with European Union trademark regulations does not affect any proceedings which are pending on the coming into force of these regulations before the EU trademark courts designated by Regulation 12, insofar as such proceedings relate to the application and enforcement of a European Union trademark in the United Kingdom. Now, I'm going to have to unpack that for you. Let me just step back. The jurisdiction is exclusive under the EU trademark regulation for courts which are designated as European Union trademark courts. It's explicitly under the EU legislation exclusive to them over infringement and invalidity. Now, we had courts designated in the United Kingdom as EU trademark courts. And the enabling provision under which the regulations were made was Section 52 of the Trademarks Act 1994. The enabling provision was repealed. And on orthodox principles, and we've got it in the bundle, on orthodox principles, the subordinate legislation which depends on the parent provision falls with it. So you have a situation in which, under legislation which is already in the bundles coupled with this, the EU TMR has disappeared immediately at midnight. There are no EU trademark courts designated in the United Kingdom at that particular point in time, hence no body capable of exercising exclusive jurisdiction, the exclusive jurisdiction, whereas all the other member states have EU trademark courts in them which retain plenary jurisdiction over the subject matter of the legislation. Now, step back and look a bit further, and let's look, please, together at the mechanism by which this was achieved. This was achieved by legislation at the EU level, which involved the extinction of EU trademark registrations as such in and in relation to the United Kingdom. They just did, it's not that they expired or they were saved, they were extinguished. And by the act which extinguished them, they were immediately replaced by the comparable national registrations, and that was the intention of the EU withdrawal agreement. The extinction of the EU trademark registrations and the EU trademark regulation under which they subsisted was the direct effect of TEU Article 50 sub 3. That's the leaving provision. We gave notice, we're leaving, and TEU Article 50 sub 3 says when you finally leave, subject to the withdrawal provisions that you may put in place for continuity or whatever, EU law ceases to apply in and in relation to the United Kingdom. So we've got a perfect symmetry, so to speak, so far between Article 53, which terminates the EU trademark regulation, and these regulations here that I've just shown your lordships. But where does this leave us? Because your lordships know better than I do that one of the things which is particularly vexing about all EU legislation is that there is, I won't say never, but seldom any transitional provisions. And that means that we must, in my submission, refer to the CJEU law in relation to transitional provisions, which is most clearly the judgment in O'Brien versus the Ministry of Justice number 2 on reference from this court. Can you find that for me? I've momentarily lost it. I'm sorry, my lords. This is quite dense. I'm told it's tab 168, thank you. 2670. 2670. Thank you. So this is on reference from the UK Supreme Court. It's sufficient to cite the paragraphs which state the rules, and those paragraphs are to be found on electronic page 2675, and it's paragraphs 26 and 27. It should be recalled that according to settled case law, procedural rules are generally taken to apply from the date on which they enter into force, unlike substantive rules, which are usually interpreted as applying to situations existing before their entry into force, only insofar as it follows clearly from their terms, their objectives, or their general scheme that such an effect must be given to them. It must be added that a new legal rule applies from the entry into force of the Act introducing it, and that while it does not apply to legal situations that arose and became definitive prior to the entry into force, it does apply immediately to the future effects of a situation which arose under the old law and to new legal situations. The position is otherwise subject to the principle of non-retroactivity of legal acts only if the new rule is accompanied by special provisions which specifically lay down its conditions of temporal application. Now, the only provision in the EU withdrawal agreement, which deals with existing proceedings, is Article 67 of that agreement. And it has saving provisions for jurisdiction. And to cut this short, it preserves, in relation to existing proceedings, the rules relating to simultaneous and successive actions. You know, the judgments used to be the Judgments Convention, but the judgments regulation type situation, there are rules in the EU trademark regulation which have been preserved by Article 67. But as we submit in our written case, they do not have the effect of treating the UK new right at the national level as the equivalent of, which it can't be, it simply can't be, as the equivalent of the EU TMR, EU TM registration, which has been extinguished. It just doesn't happen. What it means, therefore, is that you have a scheme for rules for simultaneous and successive actions and how you correlate them across the EU in relation to situations that were pending on exit day. But there's an imbalance, because on the application of those rules, if you take them as you find them, they preserve the jurisdiction of all the EU trademark courts in the EU 27 ongoing to deal with exclusively with infringement and invalidity, and they do not confer any power on the UK courts to do so. And as my lords helpfully drew our attention to yesterday, when you read the schedule, the relevant schedule to the Trademarks Act 1994, and especially in the light of the presumption against extraterritorial application, this of all situations, we would say, inevitably produces the situation that no court in the United Kingdom is competent to rule on the validity or infringement. And it must be right, surely, I say, it must be right. At midnight on the relevant day, when the guillotine came down, nothing done in the United Kingdom the following day could be an infringement of an EU trademark. There's no point. It's just a meaningless thing to say that the court in the United Kingdom is seized of proceedings if there's no subject matter capable of being infringed. That's why the EU had to give us the substitute right. Now, what does this mean in terms of what law we're applying?
If I could interject, it hadn't struck me yesterday until I was reading the provision again later, that the provision relied on, which is subparagraph 2,
Yes.
Begins with the words subject to subparagraphs 3 and 4.
Yes.
And they're the ones that say that
Yes.
you effectively deem it to be a UK trademark.
Yes, no, forgive me, you don't, what do you deem, sorry, I'm getting too personal and familiar. What do you deem to be what? The answer is, you've got a new UK trademark which comes into existence. It's deemed to have been filed as of the date that it gets, that it inherits. It's a new species of thing in its own right. It's not deemed to be anything other than what it is. It's a national right.
Well, whatever it is, it's not an EU trademark.
And let's to continue the point about deeming and non-deeming, no one is making any attempt to deem any EU registration as applicable in or to the United Kingdom. So we reached a precipice or a guillotine. It doesn't matter how you look at it, down it came. But EU law. So we've been looking at all these EU cases. The whole case was tried through to a conclusion at first instance and down to a final order on the basis of all the case law and further informative case law that we've referred you to. I'm not discerning any intention that the law should be any different retrospectively to the acts which are called into question. That I take to be covered by the O'Brien reference to, contrary to the principle of non-retroactivity. You saw that reference in paragraph 26 in O'Brien. That's what I'm taking that to refer to. It would be doubly astounding, I venture to submit, if the effect of all of this was to mean that you look at a filing under the EU system made in the period 2002 to 2008, to look at it through any lens other than the EU trademark regulation under which it was made. If one is going to decide the point at all, that must be the lens through which you look at it, I would submit. Now, the thing about the directive, however, is that the directive as far as I can tell, and I've looked at it several times now, so far as I can tell, the directive does remain as EU retained law. And the whole point about our legislation in the United Kingdom is that the 1994 Act was implemented in order to give effect to the EU harmonisation directive as it's gone on through time. That's in the preamble to the Act, and it's very clear. And one of the rules of interpretation in relation to the directive is that you interpret those provisions congruently with the corresponding provisions of the EU trademark regulation. In other words, they are part and parcel of a cohesive system of law. So because the trademark directive remains in place as EU retained law, albeit that the EU trademark regulation doesn't, because there's no subject matter left in the United Kingdom for it to attach to or bite upon, the interpretation of the UK Act still has to conform to the directive, the basic principle of conformity. Yet that's your MAR leasing rule from way back. And in interpreting consistently with that, that means that you take on board the case law that we've identified to your lordships.
And the impact of that upon the declaration of intention?
The judgment of the CJEU in our case is specifically on the operation and effect of that, and it's binding on your lordship's court. You can interpret it. I don't want to sound at all familiar, but you can interpret it, but you can't say it doesn't apply. That is binding on you.
Well, nobody's suggesting that we depart from it, so it's academic.
To the contrary, you were told in response to this question yesterday that we're ad idem, that you should be applying it, and it's in the statement of facts and issues. It's agreed that the question is, etc., etc., etc. So, I mean, we can't. I mean, the usual rule is you can't confer jurisdiction on the court by agreement. But I don't think that's what we're doing. Our position as counsel in this case is that your lordships have case law which is directly applicable in this case, including within its footprint the operation and effect of Section 3(6) of the Trademarks Act, which has got to be interpreted consistently with the CJEU judgment, which in turn says you can't use 32(3) to create a new ground of objection. It's purely procedural, they say. Not that any of us in the UK would have said that 5 years before, or 3 years before, but there you go. I'm going to be shot if I continue for much longer, and if I survive the first shooting, I'll be shot again. My learned friend, Mr. Roberts, will wish to address you if you're happy with that, to address you on questions of infringement, and then we'll give way to the Controller General's Junior on my right.
Thank you, Mr. Hobbs.
Thank you.
Yes, Mr. Roberts.
I'm going to use this as a lectern, I've been told, to be between the microphones. My learned friend, Mr. Hobbs, having addressed the court on the first order issue of validity, I'm here to address your lordships on the potentially redundant second order issues of infringement. My proposed structure, which is rapidly just turning into my submissions, is three broad topics. First of all, the context of the infringement issues in this appeal. Secondly, the status of the infringement issues in this appeal. And thirdly, at least it had been my intention to address your lordships on the substance of the infringement issues. I think in relation to that, I'm simply going to have to ask your lordships to read the, I think about 8 pages of submissions on infringement in the written case at paragraphs 192 to 246. But within the short time available, I would propose to address your lordships on the context of the infringement issues and the status of the infringement issues. What do I mean by those topics? Well, the context is, I would propose to take your lordships, first of all, to the relief that was granted below, Secondly, an overview of the three potential outcomes on validity and their implications for the infringement analysis. And then thirdly, to the narrow scope of the appellant's appeal on infringement. And then in terms of the status of the infringement issues in this appeal, my Lords, I propose to take, to meet the challenge that my learned friend Mr. Speck made to us, that in effect it must be identical goods and services infringement or nothing, because that's the full compass of the infringement issues left in the case. He appears to say that either it's been everything else has been determined against us, or that everything else has been abandoned, and we say no. There are a significant sum of unresolved infringement issues which have been held in abeyance and carried forward to this court. And then I propose to address your Lordships about what's to be done about the unresolved infringement claims. So with no further ado, the starting point is the relief granted below, as we say at paragraph 193 of our written case. The order of the High Court is at page 280 of the bundle, and your Lordships will note from paragraph 4 of the order that the injunction is in relation to infringement generally, as it was put in the Court of Appeal. There is, it's not delineated by B clause infringement or C clause infringement. It's not delineated by the selected goods and services. It's simply a thou shalt not infringe the trademarks injunction, if I can put it that way. The other notable, indeed innovative provision of the order is paragraph 4.2 on page 281, which is what we've been calling on this side the belt and braces provision. So there is a do not infringe the following EU trademarks, that's 4.1, and then 4.2, do not infringe the UK equivalent marks, because at that stage we were, I recall, in the transition period, and no one quite knew whether we were going to have a hard or a soft or a just right Brexit, and therefore that provision was put in as belt and braces. So it's there is an injunction in place in relation to the EU trademarks and any comparables that arise out. So that was, the Court of Appeal didn't interfere with that, save to extend the stay in relation to infringement. I don't propose to take your Lordships to it, but it's page 234 is the Court of Appeal's order. And the stay is extended so that if your Lordships rule that there has been infringement, the injunction will kick in 3 months after the order of the Supreme Court. And we say that it is for the appellant to show why this relief for infringement cannot be upheld, not for Sky to show why it should be upheld. My Lords, I then come to the three potential outcomes on validity, and this is the reason I say that infringement is a second-order question. It cannot be approached until validity has been determined, because you don't know what the specification you're applying for the purposes of infringement. So I propose to examine infringement under three potential outcomes on validity. And I can illustrate this by reference to bundle page 246. This is, you've seen this several times, your Lordships have seen this several times already. It's the table that forms part of the Court of Appeal judgment. So it starts at 246, and the last two selected goods and services, 7 and 8, are over the page on 247. Now, in my submission, there are really three potential outcomes on validity as a result of the way that this appeal has, the course of this appeal so far. In that left-hand column, all the way down the 8 selected goods and services, that's what my clients have been left with by way of selected goods and services following the Court of Appeal's decision on validity. So if your Lordships uphold the Court of Appeal on validity, those are the specifications to be applied. What the learned judge, Lord Justice Arnold, did at first instance is in the right-hand column. That was the slight trimming of the specifications in relation to 5 of those selected goods and services, but he left 3 of them alone. 2 because there was no challenge, and 1 because he thought it was justified in toto. That's internet portal services. So the second outcome is the modified specification. The third outcome is the appellant's primary case. And your lordships can discern that from the middle column of this table, because on the appellant's case, or their primary case, is that all of these selected goods and services under challenge should be wiped out altogether, leaving just numbers 5 and 6. So that's leaving just telecommunication services and electronic mail services. My lords, I say that those are the 3 potential outcomes on validity. Now, there were other outcomes floated. My learned friends put forward a Schedule 2 to their appellant's notice, saying, well, you could adopt the approach of Lord Justice Arnold, but maybe trim a little bit more. My lords, that was the amazing disappearing act as part of this appeal. We've heard nothing in support of the Schedule 2. It's at page 72, if your lordships want to see it. My learned friend didn't even take you to it. There's been nothing put forward. That is the schedule that was put forward at first instance and rejected by Lord Justice Arnold, was put forward in the Court of Appeal and rejected by the Court of Appeal, and my learned friends were at least on paper putting it before your lords. We say that that has simply failed at the threshold. So if your lordships are satisfied that, if I can put it this way without meaning to be impertinent, that Lord Justice Arnold got it right, then we say that the modified specification that Lord Justice Arnold came to after considering all the evidence is the correct specification to be applied. So taking each of those 3 outcomes, firstly, if your lordships go with the Court of Appeal option, that's the first column, the left-hand column in this table, then the good news for your lordships is that there are no infringement issues for this court to decide. SkyKick have admitted that their products infringe items 1, 2 and 3 in this table, in the left-hand column. That admission is recorded at paragraph 129 of the Court of Appeal judgment. There was no appeal. That's at page 274 for your lordships' notes. So if your lordships uphold the Court of Appeal on validity, there are no infringement issues, admitted infringement by SkyKick. If the High Court option, then we say that the trial judge's findings of validity are going to be upheld, and therefore we say his findings of infringement should also be upheld. Malone and friends are attempting to carry the trial judge shoulder high on a number of different fronts, but haven't really grappled with the fact that he found infringement in relation to both SkyKick products. And we say that subject to the possible Sir Christopher Floyd wrinkle about email services, which we cover in our written case, we say that there should therefore be infringement. However, we would also then get into the question of, in my submission, the unresolved infringement issues, which I'll come to. The third option is the SkyKick option. That's we're only left with telecommunication services and electronic mail services. Therefore, we are left with the trial judge's findings of infringement in relation to electronic mail services and telecommunications. And again, we say the unresolved infringement claims. My lords, I did wish to make the point that the scope of the appeal before your lordships on infringement is very narrow. The permission to appeal application before your lordships at page 25, there were only 2 issues sought for permission to appeal, though both issues of validity. And all that was said in the grounds of appeal at paragraphs 55 and 56 is that the invalidity case knocks out computer services and electronic mail services. Sir Christopher Floyd's obiter comments in the Court of Appeal are to be preferred to the trial judge's finding that that was infringed. So we've heard a number of additional non-infringement arguments run. none of which are, we say, within the scope of the appeal, including my own friend Mr. Speck's argument about the 8th selected goods and service, where he talks about information/data being somehow amounting to an abandonment of text and images and video and so forth, which I will come to. So, my lords, we say that there are, and if necessary, there are still unresolved before this court, broader and other infringement claims. So by that I mean in relation to the other selected goods and services, because we only have findings from the High Court and the Court of Appeal, to the extent that was necessary to entitle my clients to relief. The other selected goods and services, infringement under the B clause in terms of similar goods and services, and the C clause infringement. There the judge held that we technically won in relation to the C clause. He says that in the 4th judgment, but he didn't consider it added anything to the case, and that therefore didn't really need to be considered. So the debate between my own friend Mr. Speck and I is whether the existing findings of infringement are at least findings or at most finding. He says that the findings of infringement are the only findings of infringement in the case. That is the most that can be said to be infringed, and we say no, they are at least findings. And we find our support for that in, well, first of all in the main judgment, but I think most directly in the 4th judgment. This was after the 3rd judgment, where the Lord Justice Arnold had held that the email services were infringed by cloud migration. And he said in that judgment, it's page 500, paragraphs 42 and 62 of the 3rd judgment, Lord Justice Arnold had said that the SkyKick products infringed at least in relation to email services. At least. There was then a debate in between the 3rd judgment and the 4th judgment about what that meant, because my learned friends for SkyKick sought a declaration that nothing else was infringed. My lords, this is in the confidential bundle, but I don't think it's a confidential aspect of it. It's confidential bundle, page 52.
Well, before we look at it, can we just check that nobody is claiming confidentiality in relation to anything you're about to refer us to?
Certainly, I'm sure there's no confidentiality objection to what I'm about to submit, but, well, just that's the only place we can find that there was an application by SkyKick for a declaration that nothing else infringed.
Can you accept that?
You can look at that.
You could look at that, he says.
Yes. It's confidential, say, page 52. I'm not even going to risk reading it out to your lordships, but it's paragraph 22 and through 22 through 27. That sets out the debate over the minute of order, because we said that at least meant at least, and the other side said no, that is the only infringement finding, and that therefore, inter alia, cloud backup goes free, is non-infringing. And your lordships can see that debate played out in paragraphs 4 to 11 of the 4th judgment, paragraphs 506 to 507. And long story short, there's no declaration of non-infringement, and the judge said, actually, cloud backup infringes as well, because it infringes the 8th selected goods and service, and it does so not only on the basis of identical services, but also on the basis of highly similar services. So there, Lord Justice Arnold was explicitly finding in paragraphs, I think 6 and 7 of that judgment, that if not identity, then close, or I think he put it highly similar. Learned friend Mr. Speck then said that the similarity case was abandoned and that my clients had restricted their case to identity. We made it absolutely clear in my submission. I list in the footnotes under paragraph 205 of our written case the fact that the similarity point has been raised and argued. We fully explained in our trial skeleton that we said these goods and services are identical, but if not identical, then clearly similar. And by the end of the trial, all that my own friend didn't actually take you to our closing skeleton. He said that we'd restricted our case at that point to identical. We say no. All we said at that point is that Mr. Schwartz had admitted in cross-examination all of our identical goods and services. That's the table set out in the written case. So Lord Justice Arnold didn't need to worry about similarity because there was clearly identity. Of course, thereafter, we got into the question of narrowing the specifications, etc. My Lords, we did carry forward to this court, well, first of all to the Court of Appeal by way of Respondents' notice, and then to this court in our notice of objection and our notice of acknowledgement, these residual issues under the B clause similarity, other selected goods and services, and the C clause. If you want, your Lordships want the page references, it's 652, 659, 702. We say perfectly properly complied with Practice Direction 8 of the Supreme Court and Supreme Court Rules Section 25.1. So those are before your Lordships. We didn't need to cross-appeal because the injunction is in relation to infringement generally. It's perfectly proper to have done that by way of Respondents' notices. My Lord, in terms of the arguments that have been put forward by my learned friend Mr. Speck, which aren't in his appeal notice, we give the answer in relation to selected goods and services para 8 at paragraph 238 of our written case. This is where, and if your Lordships have it, the goods specified are computer services for accessing and retrieving information/data via a computer or computer network. And that was shortened from information, messages, text, sounds, images, and data. As to that, we say information data was simply a shorthand for all of that. Not only is this an entirely new point raised by my learned friend in his written case, it's actually contrary to the case they put before the Court of Appeal. That's page 541, paragraphs 100 to 102. And it's also contrary to to the late lamented Schedule 2 before this court, which is at page 72, because there they say, actually, Sky, if the learned judge was correct in the approach, Sky should have computer services relating to documents. So that they appear to be conceding that documents are still within the case. Well, the final question is actually the $64,000 question, which is what should the Supreme Court do in relation to the unresolved infringement issues? SkyKick say, and I have some sympathy if this were the case, that it's impractical and inappropriate to ask your Lordships to carry out major analysis afresh. We say we're not asking your Lordships to make new findings of fact or rely on fresh evidence. We say that if this court concludes that fresh factual investigations are necessary in order to determine whether those whittled down specifications have been infringed, then your Lordship may feel that the appropriate case management course is to remit the determination of those unresolved infringement claims to the High Court. But we say that is not the case. We say that your Lordships can properly reach a conclusion on the unresolved infringement claims. We say it follows from the unappealed findings of the court, of the courts below, and the findings of fact which they made, and the basis of the evidence, and we go into that at paragraphs 219 to 238 of our skeleton. We say that that this court can and should, on the basis of the existing unchallenged evidence, applying agreed legal principles, reach what we submit to be straightforward conclusions, that even if there is no identity on some of the selected goods and services, there is nonetheless similarity infringement, or indeed C clause infringement. One final point. I'm sorry, I'm trespassing on the controller's time. We did start slightly late. Malone and friend Mr. Speck seem to suggest that where classes are different, there can't be identity or similarity, and that where there's a registration in class 42, for example, that can't be infringed in class 38. Well, both the High Court judge and the Court of Appeal in this case have said that there is identity across the class, and we say that's perfectly orthodox law. Section 60A of the Trademarks Act 1994, bundle page 105, says that when assessing this degree of similarity, you can't say because it's in a different class it must be dissimilar, or because it's in the same class you can't say it's similar. It's simply, the needs classification is no guide.
I understood the submission to be that it's not the same.
Well,
if they're in different classes.
Yeah. And we say that's...
Similar is different.
Yeah, we say that's wrong. We say that, first of all, Section 68 is talking about that analysis of similarity. We say in this case below and in the Court of Appeal, we have findings of identity, and that's perfectly orthodox. And there are a number of cases where identity has been found on a perfectly orthodox basis between two different classes. The only case Malone and Friend was relying on was a non-use case, which is a different analysis. We say from the infringement analysis, I found with apologies to any vegans who are listening, found a case where albumin for culinary purposes in class 29 was found to be identical to protein for human consumption in class 5. So it's frequently the case that there is some overlap, and that doesn't stop things being identical. But of course, your lordships have the point that we say we are not restricted to identical goods and services. We say that we've properly carried those issues forward, not abandoned them. They've not been determined against us. I'd be delighted to have any questions from your lordship, but I've already trespassing on the controller's valuable time. So unless I can assist your lordships further.
Thank you. Well, Ms. Edwards-Stewart, you don't lose any time. We will hear you for the full half hour.
I'm grateful. My Lord, subject to any questions you may have, the Controller wishes to make 3 points. The first of those, and the Controller's principal concern, is that it's keen to ensure that it retains the right to raise bad faith objections at the examination stage in circumstances where, on the face of the application, there's a prima facie case of bad faith, but equally keen to ensure that it's not encumbered with an obligation to assess bad faith at the examination stage in each and every case. The second issue relates to what has been referred to in this case as overly broad terms, and the third issue relates to the requirement for a statement of case positively setting out the positive intentions of the trademark proprietor. But before I make those submissions, it might be useful to provide some context to the Controller's position. The principal function of a trademark is to identify the source of goods and services that are supplied under that trademark in the course of trade. Accordingly, implicit in the system is an expectation that there is some correspondence, however loose or ambitious, between the application for a trademark and the applicant's commercial activity, actual and/or intended. And this is reflected in the declaration in applications for UK trademarks that the party has an actual intention to use the mark for the goods and services for which it's seeking registration. The other context is that the UK IPO receives more than 150,000 applications to register trademarks each year. Each of those applications is subject to examination. That's an ex-parte process undertaken by the UK IPO. About 93% of those applications are then published, and about 4% of those published applications are opposed. An opposition is an inter-parties application before the UK IPO, where interested third parties can oppose the proposed registration of a trademark. So that's about 5,000 to 7,000 oppositions a year. Post-registration, the validity of the mark can be challenged by third parties before the UK IPO or the court. the UK IPO typically receives between 300 and 600 applications for invalidity and revocation each year. And although we don't have data, only a fraction of registered trademarks actually end up in court proceedings, typically the High Court or IPEC, in which the validity of the marks are tested. So very few trademarks actually have their validity tested as against the full gamut of the CPR processes of disclosure, witness statements with cross-examination, and fewer still with the energy and effort that's been undertaken by both sides in this particular case. And so accordingly, this case is the exception rather than the rule in which these sort of issues arise. Now, addressing you as to the Controller's principal concern, the Controller's principal concern on this appeal is to ensure that it retains at the ex parte examination stage the right to raise an objection in respect of applications which are prima facie an abuse of the system. And the paradigm example of such a case is an application that seeks to register as a trademark a word for each and every category of goods and services within the 45 classes that are identified in the NIS system. And for the purposes of this exercise, it doesn't actually matter whether or not those goods and services have been drafted by reference to the class headings or whether or not they've been drafted by reference to an exhaustive and extensive list of more specific categories or headings. And such an application is, we say, prima facie an abuse because it is simply inconceivable that any business, existing or putative, has an actual intention to trade in such a wide range of goods and services as covered by the entirety of the NIS classification system within 5 years of registration of the mark. So, for example, these include goods as disparate as varnishes in Class 2, perfume in Class 3, oil for the preservation of masonry in Class 4, pharmaceuticals in Class 5, bolt screws and nails in Class 6, and incubators for hatching eggs in Class 7, etc., through to Class 45. Accordingly, because it's prima facie incredible that a business can have a realistic intention to trade in such a wide range of goods and services, such a wide range of specification gives rise to a strong but rebuttable inference that the mark was in fact registered for some other purpose, namely undermining, in a manner inconsistent with honest practices, the interests of third parties, and or of obtaining, without even targeting a specific third party, an exclusive right for purposes other than those falling within the functions of the trademark. And so we say that there is nothing in either the domestic or the European case law which suggests that that is an illegitimate approach, because it is giving rise to an inference that something else is taking place and it's not merely a lack of an intention to use. And we say that those marks, if permitted to proceed to registration, would indeed clutter the register. They would become earlier marks that serve to restrict the registration of future similar marks, and they also act as a deterrent for traders who wish to come onto the market with a similar mark. And for those reasons, we say it's important that the controller has a right to object to those applications where there's a prima facie case of abuse. However, at the same time, we say that it must equally be borne in mind that at the examination stage, the examiner has, or may have, no actual knowledge as to the nature or scope of the applicant's business, or indeed whether the applicant even has a business at all, less still what the subjective intentions of the applicant are. And therefore, the UK IPO is simply not in a position to conduct any sort of investigation as to the actual subjective intentions of the applicant, so as to determine whether or not an application has or has not been applied for in bad faith, in whole or in part. Nor does it have anything close to the resources that would be required were it obliged to do so. And it's for this reason that the UK IPO wants to ensure that it's not obliged to investigate bad faith in every case, but when presented with an application which on its face represents a prima facie case of abuse, it can raise an appropriate objection to the registration of such applications as appropriate. The Second point which the controller wishes to address is that concerning overly broad terms. And we have seen from paragraph 113 of the Court of Appeal decision that the Court of Appeal appears to preclude a finding of bad faith in respect of overly broad terms to describe goods and services in circumstances where the proprietor had an intention to use the mark in relation to some but not all of the goods and services encompassed by that term. It's not immediately clear, at least not to the controller, whether the Court of Appeal has also ruled out a finding of bad faith in those circumstances, even if it can be shown that the applicant's real intention in using that broad description was to misuse the registration system in order to acquire legal rights going beyond anything that could possibly be justified as the proprietor's legitimate interest in protecting the functions of the trademark. And the controller's primary position is that bad faith must ultimately be judged on the applicant's intention rather than the truth or partial truth or falsity of the declaration of an intention to use. Of course, we accept that an untrue declaration of use may constitute evidence of bad faith, but it's not determinative of the matter. Equally, the literal truth or partial truth of such a statement should not preclude a finding of bad faith. And specifically, where an applicant has made a statement which is literally or partially true, for example, we intend to use the mark as registered for clothing in circumstances where the intention is limited to ski gloves, we say that even in those circumstances, it may still constitute bad faith if the reason that the border specification was chosen was for the impermitted purposes of additional protection, unjustified additional protection, or to thwart third parties. But obviously in such circumstances, the evidence required to support such an allegation will necessarily need to be more persuasive than in circumstances where there's no actual use at all. So, in summary, we submit that even where an applicant can point to some subset of the overly broad term in respect of which it did in fact use or have an intention to use the mark, that should not preclude a finding of bad faith, where on the evidence the actual intentions of the applicant in selecting a broad term are established to be an attempt to require rights over and above those that could be justified or to undermine the interests of third parties. In those cases, the use of an overly broad term should amount to bad faith, and the applicant or proprietor should not be given effectively a get-out-of-jail-free card simply because it can point to some subset of the broad term, however tiny, in respect of which it had a genuine intention to use the mark. And we also observe that a potentially unintended consequence of the Court of Appeal's judgment is that it may now be possible to object to the inclusion of specific descriptions of goods and services on the basis of objective, relevant and consistent criteria, but not the broader description. So, for example, a party might be able to object to ski gloves in Class 25 on the basis that proprietor had no intention to use the mark for ski gloves, and it included ski gloves only to support an aggressive opposition strategy, but could not object to the broader class of clothing, footwear and headwear because the proprietor did have an intention to use the mark for, say, fancy dress costumes, which are still covered by that broader class. And immunising the use of overly broad terms in this way is likely to encourage the use of overly broad terms to cover narrow and specific categories of goods and services, and as a result in cluttering. And finally, on the subject of the requirement for a third party to identify precisely which goods and services are the subject of the bad faith allegation, insofar as that requires a positive statement of the subjective intention of the applicant or proprietor, our concern here is that there's a potential risk that the imposition of such a strict additional procedural requirement, particularly at a very early stage of the proceedings, may become a tool which proprietors can exploit to stifle the commencement or continuation of legitimate applications to invalidate marks for bad faith. Whilst the applicant may well be able to identify specific categories of goods and services in respect of which, by contrast with the proprietor's actual business, the applicant can draw an inference that the proprietor had no intention to use the mark for those goods, for example, baseball caps, ski boots, this will not always be the case. And particular difficulties will arise in the context of overly broad claims. Overly broad terms. Say a party has registered its mark in Class 25 using the class heading clothing, footwear, headwear, as well as the narrower terms of shirts, blouses, jackets, baseball caps, ski boots, masquerade costumes. As mentioned, it may be relatively straightforward to identify baseball caps and ski boots as goods in respect of which the proprietor has never, in fact, traded or apparently sought to trade. But what about the broader class of clothing, footwear and headwear? It will be difficult, if not impossible, for the applicant to list exhaustively the subset of clothing, footwear and headwear that the applicant contends that the proprietor did not have an intention to use. And the broader the terms, the harder that exercise becomes. Given that a finding of bad faith ultimately turns on the actual intentions of the proprietor, and given that in almost all cases a party alleging bad faith, often in response to a claim for infringement, the party will not have direct or personal knowledge as to the actual intentions of the proprietor. Accordingly, in almost all cases, there will be an information asymmetry as between the proprietor and the party alleging bad faith, which may hamper the ability of the party alleging bad faith to produce the necessary statement of case. Furthermore, the proprietor could act in a way so as to perpetuate the information asymmetry. It can resist disclosure and adduce no evidence, making it progressively harder for the applicant to identify the relevant goods and services that were the basis of any positive intention to use, less still obtain the necessary objective, relevant and consistent criteria on which it relies to establish its case. And whilst there may be a place for statements of case of this sort in the context of High Court litigation, with all the disclosure, witness statements and cross-examination, they might become restrictive in examination or even opposition proceedings, where those steps might not take place and may serve to deprive applications of bad faith of any effect at all. And in particular, we observe that if the justification for the requirement of the statement of case is to provide fairness for the trademark proprietor, then logically that requirement would also apply to the controller. If the controller was required to effectively produce a redrafted specification aligned to its understanding as to the actual intentions of the proprietor, it would be almost, or applicant at that stage, it would be almost impossible for the registrar to object to even the paradigm abusive applications that we mentioned at the outset. And for those reasons, we suggest it should not be necessary for a party alleging bad faith to plead what specification the proprietor could legitimately apply for in order to raise a prima facie case of bad faith. And in support of that, we adopt the reasons that Lord Justice Arnold gave in paragraph 55 of the judgment in Lidl and Tesco, which are in the bundle at pages 2249 to 2250. And unless there's anything else, they were the 3 points that we wish to raise.
Are you able to assist us as to where the line should be drawn and how it should be drawn in relation to the good bad faith requirement?
Well, we accept the decision, obviously, that was made by the CJE and the requirement that there must be these relevant, objective and consistent indicia, and where those are present, they can give rise to the finding of bad faith. Over and above that, it's very difficult because obviously it's an incredibly fact-sensitive dispute that will ultimately turn on its own, each case will ultimately turn on its own facts as to what those indicia are or are likely to be.
Well, thank you very much indeed. We're most grateful to the Controller for his intervention.
I think we've agreed that I shall have a short reply, and then my learned friend, Mr. Speck, shall have the last word. Let me be brief. I heard at one point that the registrar is receptive to the point that it's not merely a lack of intention to use which will give rise to the bad faith objection, that the registrar will be looking for systematic abuse of the system. Yes. The problem starts and doesn't end with the statement that there can be bad faith with overly broad terms. A lot of time has been spent during this hearing, relatively speaking, during the 2 days, on the question of what is an overly broad term. It's a relative statement, and the criteria for determining what is what shall I call it? I called it a platonically correct term, requires an investigation according to criteria which nobody has identified. Your Lordships may identify it in due course, but nobody this side of the bar has identified any of the criteria. That there can be somehow a whole set of things that an applicant must actually be challengeable on by reference to his own aspirations, financial resources, the state of development of his business, and the timelines on which he may be working to do anything, and how much of it might be regarded as unreasonable hope more than expectation. Is unreasonable hope to be regarded as bad faith? Surely not. So we're not much further forward on the proposition of what is an overly broad term, or a collection of overly broad terms. And I tried to demonstrate to your Lordships this morning in particular that this whole notion of intention to use is extraordinarily elastic, leaving aside the fact that it's entirely subjective, albeit you assess it objectively, whether there's been bad faith. Now, I don't know, I'm beginning to infer that the registrar may be asking you to depart from SkyTech and Pelican, SkyTech in particular, but Pelican is the other one, where they say that there is no prima facie bad faith. I think that's the fair way of putting it. There's no prima facie bad faith in having a long list of services or goods. Prima facie, there's no bad faith. Add to that the rebuttable presumption of innocence, which everybody is entitled to under the existing law, and no one would deny it as a matter of English natural justice. I'm not seeing myself how the registrar will actually operate this system. I can understand without any hesitation, there have been cases, we're well aware of them, Alexander trademark was one of them, where it was obvious on the materials that were in front of the registrar that there was a manipulation of the system used in conjunction with a procedure for effectively blocking and ransoming people for money. Those cases present no problems. They're not mere non-use cases. They're not mere extension of extensive filing cases either. They could be just as objectionable if it was one listing or one itemisation of goods or services. The question is, where does the evidence come from to overcome the presumption? And anything in our submission which involved not requiring an objector to state a case would be fundamentally wrong. The objector has to state a case. Has to. What is the person concerned accused of doing? Is that an objective which it is not legitimate to pursue? And has the accusation been made good? Those are the three ingredients of what a proper statement of case should be. The rest will be evidence and procedure and all the rest of it. A long-ish list of goods and services doesn't suffice so long as Pelican and SkyTech are the law. I think that's all I want to say at this point. unless there's any questions that you have at this point that before we all depart.
I don't think so, Mr. Hobbs. Thank you very much.
Thank you, my lord.
Mrs. Beck.
My learned friend started his submission yesterday by looking at that table in the Court of Appeal judgment that showed how the trial judge had restricted the individual terms in issue in selected goods and services. He looked, for example, on the restriction of the term, the software term, to the particular type of software that the judge limited them to. And he sought to suggest that the case was actually of very modest restrictions. He even called it minuscule, an ambitious submission, I would say, given how vast software is without the qualification. But the point he was building to was a suggestion that it was implausible that there was a bad faith in the sense of an intention to use purely as a legal weapon in the area that had been covered, but cut back because the judge had considered it improper. And just for my Lord's note, I have in mind the submissions he made in the passage bridging pages 150 and 151 of yesterday's transcript, where I think he even used the word implausible. And he built on the suggestion to suggest this case was not about applying without intention to use, with an improper purpose, but simply about granularity is what's included in the application. And my Lords, what this approach is really doing is asking my Lords to ignore the clear findings made by the judge as to Sky's conduct. And it also seeks to airbrush from history everything in the vast swathe of the specification, bleaching preparations, fuel additives, whips, Gladstone bags, and so forth, and treat the case as if the specification had only ever had the selected goods and services. He's trying to go behind the judge's findings. He made a finding, the judge that is, that Sky has a strategy of seeking very broad protection regardless of whether it was justified. Can I show my Lords that again, just to be absolutely clear? It's the end of paragraph 250 of the main judgment on page 366. It's right at the end of that paragraph. And this paragraph is actually at the end of the section starting on page 362, where the judge explained, for example, at para 240, so these are the paragraphs leading up to that, at 240 at the foot of page 362, that Sky disclosed nothing setting out, let alone explaining its filing strategy. No one from their IP team gave evidence as to Sky's filing strategy, in particular their reasons for seeking such broad protection. That's para 241 on page 364. The only witness who did give evidence as to Sky's intention was Mr. Tansey. So when my friend yesterday complained about my characterisation that Sky didn't put forward any explanation of what it specifically intended, which might have supported a cutback specification that it might have put forward, which of course it didn't put forward either, and said that there was voluminous material, he's wrong. He's probably referring to the evidence Sky filed as the kind one might file in a non-use case of specific activities that have been undertaken. It did that to be sure, but nothing that comes close to what I'm referring to and what the judge was looking for. This passage of the judgment continues to set out the core of Mr. Tansey's evidence. This is para 245 at the foot of 363 through to 364, and my Lords will notice that that was also reproduced by Sir Christopher Floyd. Just for your note, it's paragraphs 84 of his judgment, and they both set it out because it's as good as it gets. It comes nowhere near what would be necessary. For example, it simply asserts in paragraph 36 of the evidence, looking in the quote, that there were sound commercial reasons for broad coverage, and a little later that there was no commercial sense in foregoing the protection for prospective use. But just pausing there, my Lords, to meet a prima facie case of bad faith, one at least have to identify the commercial plans or reasons applicable to different goods and services, so the court can assess whether it's a permitted intention that falls on the side of the use of a trademark, or whether it's on the side of using the system as an abuse. One can only pause and think, what would Hasbro have done? They would no doubt have said that they had sound commercial reasons. Target Ventures no doubt would say that. Likewise, Lidl, in its case. It's not for the applicant to tell the court that it was sound. It's for the applicant to tell the court what the intentions were, for the court to judge whether or not they were legitimate or an abuse. But that's as good as it gets. My lords, the passage goes on. This is para 246, to record that Mr. Tanz's cross-examination, in his cross-examination, he was frequently unable to say Sky had any intention to use in relation to particular goods and services. Rather, he sought to put forward ex post facto rationalisation. That's important. There's a difference between what Sky actually did intend at the time, which is what matters, and many years later trying to come up with some reason that might justify the conduct looking back. Para 247, this is on page 365, records that Mr. Tanz's suggestions, including suggestions that were rather far-fetched. My lords, my submission is this: even those that are not far-fetched don't count when they're ex post fact rationalisation. It's intention at the time that counts.
And those that were found to be far-fetched included some which paragraph 72 were found to have been the subject of enforcement.
Yeah, exactly. I'm going to come to that. So some of them were far-fetched, but my point is it's not anything that's just an ex post facto rationalisation doesn't count. And paragraph 249 explains that there were instances where even a far-fetched ex post rationalisation wasn't forthcoming. And it's after that, so after all of that material, that we get to the conclusion in paragraph 250 that I started with my lords on. And my lords know that the judge returned to this in his third judgment, where he characterises Sky's conduct. This is page 496 of the electronic bundle. It's paragraph 21.
Well, perhaps just it may be worth noting that you've taken us to the last sentence of 250, who then goes into this in more detail in 251 and includes the particular matters that we're concerned with.
My lord's ahead of me, but I was going to do it because...
Oh, all right. Well, you do it your own way.
But we are going to that, but we're going to look at it in the judgment because he re-quotes it. But my lord's absolutely right that that paragraph is important. I was on paragraph 21 in the fourth judgment on page 496 of the electronic bundle. He's characterising the strategy as a deliberate strategy of seeking very broad protection, regardless of whether it was commercially justified. Sky applied for the trademarks with the intention of obtaining an exclusive right for purposes other than those falling within the functions of a trademark. Pausing there, my lord, that is a finding of fact, express finding in terms satisfying the second limb of the test in this case. Wording that my Lord Reid actually raised with me yesterday, that as to whether that was my case, as to whether Sky fell within it. Yes, it is, and it is because that's what they were doing, and there the judge is finding it. And he identified the illegitimate purpose, used purely as a legal weapon against third parties. The judge specifically identified both threats of infringement claims, so that's in the actual market, and opposition, so blocking others getting registrations, and referred to the paragraphs in the main judgment where he'd addressed Sky's extensive activities in both those regards. These are the crucial findings of fact that the judge made, and it's obvious, my lords, that the judge concluded that in respect of each of the categories that he then decided could not stand, that the category had been framed pursuant to this strategy to cover goods and services Sky did not intend to use in respect of. That's why he concluded they couldn't keep it. And my lord, the judge expressly says this is one of the ways in which overbroad protection was sought. It's in that paragraph 251, but my lords can see it in the fourth judgment because he's quoted it, so I was going to refer to it there. quotes it on page 496. It's the second way identified halfway through that paragraph. So he explains the different ways in which the strategy was pursued to get overbroad protection, and the second way is precisely this. Including a category of goods so broad Sky could not and did not intend to use across the breadth of the category. And please note this, His Lordship specifically gives computer software as the paradigm example. He gives that. He's making a finding of fact that actually they've done it in this way generally, and he gives as the example computer software that my friend stood up and has made a submission to my Lords that he only cut it down in a minuscule way and in a way where he couldn't plausibly be holding that there was this kind of bad faith in the bit that he was cutting out. On the contrary, he's express about it. Now, my friend seeks to build a case that the terms in the selected goods and services were not, that were cut down, were not tainted. They were not tainted by this idea that they were going to secure exclusive rights over them, particularly for use purely as a legal weapon. And we say that is completely untenable, and it's obvious that in respect of each of them, each of the categories that he cut down, the test for bad faith is satisfied on the judge's findings. And I do emphasise, in respect of each of them, Sky has not proffered any cutback version nor any explanation as to his intentions at the time that might justify some narrower version of it, some kind of wording coupled with the kind of thing that the judge was looking for and saying there wasn't in the evidence that might justify some alternative narrower scope of protection being left with, other than that which you would get from the prima facie case that the term has been applied for in bad faith. So, my Lord, that is really important that you understand the findings that have been made and the trouble that my friend is in. And really what he's trying to do is to ask you to go behind them and disregard them. That's the end of that particular topic. Can I turn to something that...
Just before you leave that, Sir Christopher Floyd, I think at para 118, somewhat downplays what you've described as not really being very satisfactory findings of fact. What do you say about that?
Sorry, 118.
Paragraph 118.
Yes.
As if the judge was dressing up to use the words of the CJEU, but it was difficult actually to pin it.
I have to say, I read what he's getting at there is another species of the, if there's anything in there that's good, the whole thing's good.
Right, okay.
I think that, I don't think I'm being unfair to him, because he's getting at, it's the partly point. So,
right.
I think that's what he's talking about. I mean, that is a big difference between Sir Christopher Floyd's approach and the judge, obviously. And also, I think, the global basis as well, when one's looking at that language in there.
Yes, thank you.
Yes. And actually, as I'm reminded, the factual findings are the factual findings. Can I move on to address a point that the controller has made? And it's a point that jumps out both from her oral submissions and the printed case a bit, and that's that it's explained very clearly that one of the ways the objection can be raised, and the statutory regime specifically intends this to be so, is in examination of a trademark by the controller. Is explained in the controller's printed case at para 15, referring to section 37 of our Act. And as my friend explained a few moments ago, the controller's in possession of not much by way of information other than what is discernible on the face of the application, but it's positively intended that the controller be able to raise raise the objection. And it's obvious that the controller perceives that there's an issue by virtue of what is identified as the procedural point in my friend's submission. And that's that if you're raising an objection against an applicant where it might be said that they might have some intention that's legitimate, you've got to tell them what the scope of the specification ought to be. And that is not the right way round for inter-parties litigation at all, but it would obviously apply to the controller raising the objection. And it's another point that really reinforces in my submission that Sir Christopher Floyd has got this round the wrong way, and Lord Justice Arnold and Liddell is right. One needs to be able to raise a prima facie case, and then the burden shifts, and particularly as to regard narrower specifications, if there's to be consideration of saving something from a term that is applied for in bad faith, it must be for the trademark owner to put forward the restrictive specification with the accompanying explanation and reasons as to why that is a legitimate outcome. So we say that the concern that's been identified by the controller about the controller's role just reinforces what I've said, both about the shifting burden generally, but in particular in respect of the cutback or fallback position and where it should come from. And of course that matters here because they just did not engage. Now, can I move to explain the very narrow basis upon which there's an extant finding of infringement that's still applicable on the judge's finding as not interfered by the Court of Appeal? Because one of the points that my learned friend, Mr. Hobbs, made was the suggestion that somehow whatever happens, I'm going to lose. And in particular, what he suggested is that I'm going to lose if you go back to what Lord Justice Arnold did in terms of cutting back the specification. Now, in front of Lord Justice Arnold, there were only two specific findings of infringement, one related to the email migration product, and that was determined on the basis of a very broad and wrong construction of what email services covered, that the Court of Appeal said was wrong and said they would have allowed the appeal. So that has not survived up to my Lord's Court. The other is the last category, the cloud migration product, being held to be within a recasting of that peculiar term that my Lords will remember was an edited version. And actually maybe the best thing to do is to turn it up so that we've got it in mind. I think the table was in the table that my friend was looking at is so tab 8, sorry, box 8 on page 247 the electronic bundle. For my Lord, it's paragraph 27 of the judgment. I know your pagination is, if you're using the hard copy, a bit different. And this relates to not the email migration, but the backup product. And my Lords will remember that this has a peculiar history, this particular term. It's the one where they only took part of it. And it was quite notable that my friend Mr. Roberts suggested that it was just to save writing the whole thing out. Not that they'd actually abandoned the rest of the term, which included messages, images, sounds, I think. We've set out in our case as to what the term was before. So this is the term where there's several peculiar factors that reinforce our submission that you shouldn't leave them with it in any event. My Lords will recall it's the fact that what the judge is doing is recasting the broader bit that they didn't abandon into what is in substance the bit that they didn't take, and coming up with words which are then held to cover something which isn't in class 38 at all. And so those are additional reasons that I explained to my lords as to why you would not cut back and do what the judge did. You would just delete it in any event for that term. And that's why it's important, why I was addressing it, because that is the only basis upon which there is an extant finding of infringement that is currently before the court that has not been overturned in the way that Sir Christopher overturned the email services category. That is it. So he's got to persuade you that actually the course that is the just course to take for that categorisation, with that history, recasting it to actually cover the bit that was abandoned, and in a way that's then said to cover stuff outside the class, is the legitimate way forward. And unless your lordships stick with that, there is no infringement finding that affects my clients from the courts below. Can I move on and deal with a couple of further points? Very briefly, my friend suggested that the non-use attack was something that the judge held we should have advanced because we could have brought it in after the counterclaim but before trial. And I think my Lord Kitchen asked him for the dates as to when they could have been brought in, and no doubt he'll give them to you. My Lord already has the point that a non-use revocation is from a different date, so there's points on potential liability for damages in the past anyway. But the thing I was very surprised about is that if you go to paragraph 7, which is what he referred to, the judge was very clear about the point that I mentioned in passing, is that it didn't even apply to all of them.
Paragraph 7.
7 of the main judgment, sorry.
Yeah.
Page 310, it's paragraph 7 of the judgment that Mr. Hobbs relies upon. The crucial thing, the crucial wording, is all but one on the 4th line.
No, can you keep reading? Keep reading.
So what's your submission?
It didn't even apply to
All but one.
Yeah. But the submission, my lord, is firstly, it's not an answer because it's not the same effect. But secondly, to conclude that we should have done it when it wouldn't have applied, wouldn't have provided a defence or a point that would apply to all of the marks. How does that help? How would that have helped me? That's what we say. I can run a point that's applicable to some of the marks, but I'm being met by 5 marks. So, my lord, it's not an answer in any event because there's different dates.
The revocation for non-use would take effect as from the date of the claim for revocation.
Absolutely, the claim for revocation.
But you can't bring the claim for revocation in respect of a period of non-use until your registration has been completed.
Absolutely. Yeah.
And then
what happens is that you end up, that's why you remember at a point yesterday I paused and I said the word revocation instead of declaration of invalidity, because there are 2 different categories of things that you do. Revocation is a taking the registration off the mark from a particular point in time.
And what is the date from which it is taken off?
The prima facie position is the date of the application for revocation, but I think there is a provision that allows you to take it off earlier if satisfied that the grounds for revocation existed at an earlier date, but they still would not have come off from the beginning.
Until after the 5 years of non-use.
Yeah, there's always going to be 5 years.
I understand. So you can backdate it to the end of the 5 year period of non-use.
Yeah, you have to specifically ask for that.
Well, yeah.
Yeah, but you can't go any further because the grounds didn't exist.
Well, you make that submission, yeah.
The next point I just want to deal with as briefly as I can is the Target Ventures case. What it seemed to be, my lord, the submission that my friend made was this. That he had a quibble with their assessment of the facts, or perhaps more than a quibble, a real problem with it. He suggested that the domain name ought to have been considered to be use. That's an assessment on the facts. We can argue about that. What it is, what it stands for as proposition is that to apply for a mark that's not to be used to strengthen another mark is not legitimate. Those are the reasons they applied. Their assessment of the facts was that the domain name did not count, but you look at the reasons that they apply, is that doing what is in effect a defensive mark to strengthen an earlier mark is bad faith. And that's what the case stands for as proposition. It's not an answer in my submission to say, well, their assessment on the facts as to whether there was actually any use, any intention to use, is open to question. They were of the view that it wasn't, but given that assessment of the facts, the principle that they applied is the principle that I rely upon.
I'll ask you another question about that. How long after the date of application can a third party complain that the application was made in bad faith? Is it unlimited? Can it be made at any time after registration has been completed?
I think it can. Yes, I think it can. Yeah. Those around me will tug me if I'm wrong, but I think it.
We agree.
I think it can.
Thank you.
At any time. Can I very quickly address the Brexit point, my lords, because you'll recall I mentioned in the regime there was something in the withdrawal agreement, and my friend mentioned the thing that I had in mind and didn't show it to you, and it is important in my submission because it shows a clear intention to continue the jurisdiction of UK courts. Can we go to page 1908? It's Article 67.1. And so it's at the bottom of 1908. This is the article that's considered by the Chancellor in the Easy Group case that I've referred to that's decided this point already in my favour. Yes, sorry, did I not say the withdrawal agreement? Sorry, it's the withdrawal agreement.
It is the withdrawal agreement, yeah.
It's the withdrawal agreement. So this is an agreement, the withdrawal agreement, and you see it provides in pending proceedings in the United Kingdom as well as in member states, in situations involving the UK, so both ways round this is, in the United Kingdom courts and the member states, in respect of proceedings instituted before the end of the transition period, and then there is wording referring to other proceedings, so not necessarily pending, but related to pending proceedings under the provision, which are the rules on lis pendens and the like that my friend referred to. So, and then there's a list of provisions that continue to apply. And the second one is the provisions regarding jurisdiction of Regulation 2017/1001. That is the trademarks, European trademark regulation. So its rules regarding jurisdiction, for your note, they're Articles 122 to 135, and they include providing jurisdiction over infringement and validity of European trademarks. So this is providing not just, as my friend suggested, for continued jurisdiction only on related proceedings, It's providing for pending proceedings and proceedings relating to pending proceedings, that the jurisdiction continues in the UK courts under the European Trademark Regulation. And that's the thing upon which that subparagraph 2 in paragraph 20 of Schedule 2A of the Trademarks Act is based, the one that provides for continuing as if we were still a member state. It's a perfectly sensible rule for pending proceedings. Otherwise, you might get to the day before judgment, IP completion date, and you have to go back and start again because you've got Brexit before the judgment's handed down. And can I leave, my lords, with this point about why this is important? It's not so much what law you're applying, because we're all agreed that the European cases are applicable. It's the device or the effect that my friend is trying to achieve by this. It's not that he's simply trying to shield his European trademarks from my lord's decision. He's trying to do that. He doesn't want the effect of my lord's decision to apply to his European trademarks. But he currently has an injunction, stayed pending appeal, restraining infringement, and he's even asking my lords to make further findings of infringement. And he's trying, as I understand it, to engineer a position whereby, even if my lords are with me and would declare the terms that I attack in the selected goods and services as invalid, or recast them in a narrower form so there's no identity and no infringement, he nonetheless retains an injunction to restrain infringement that's already in an order, and the European mark retains its broader protection because it doesn't get the effect of my lord's decision. So that's the thing that's really pernicious about what's going on here. He's trying to keep the European mark in the broad specification regardless of what you say, and to keep an injunction biting on my clients in this jurisdiction. That's the ploy we detect. And whatever view you take on the Brexit point, it simply can't be right that you allow that. You allow an injunction to remain covering a monopoly that you've concluded is illegitimately wide, but for instance, if you're persuaded by him, that you don't declare is invalid by virtue of the Brexit point. So that's why it's really important, my lord, that you see what's going on. He wants an injunction to bite on a monopoly, even if you conclude it's impermissibly wide. I'm really grateful to my learned friend because we're back on track because she was so economical. Unless my lords have any further questions, those are the reply submissions that I wanted to make.
I don't think we have any further questions for you at the moment. Thank you.
Could I just inquire whether my Lord Kitchen still wants me to produce a schedule of those dates?
If we have the relevant dates, Mr. Hawkes, in the papers already.
The dates when the registration procedures were completed?
Yes.
Yes, they're in the chronology which is attached. I think it's attachment 2 to the SOFI. Statement of facts and issues.
It's attached to the present statement of facts and issues.
Is it there?
It is. You've just got to add 5 years onto it.
In that case, Mr. Hobbs, for my part, I don't think I need anything more.
Thank you.
Well, we're grateful to all counsel for the assistance they've given the court, and as I said earlier, particularly to the controller for intervening. It's going to take us some time to produce a judgment in this case, but we'll let you know when we're able to. The court will adjourn.